Good morning. I am here to speak to you today about the Domestic Abuse Protection Scotland Act 2021. Domestic abuse remains a significant issue in Scotland, affecting hundreds of thousands of people each year. The Domestic Abuse Protection Scotland Act 2021 was passed by the Scottish Parliament and received royal assent on the 5th of May 2021. Its core purpose is to provide immediate and flexible protection for people at risk of domestic abuse by partners or ex-partners through a civil protection regime distinct from criminal prosecution. Notwithstanding that, most of the Act has not yet been brought into force. There are a small number of sections due to come into force later this year, and I will highlight them as and when we get to the relevant points in the seminar. The Domestic Abuse Protection Scotland Act 2021 is, despite that, an important act for various reasons. Firstly, traditional criminal proceedings can be slow and may not immediately prevent further harm. Protective orders available through the civil courts, such as interdicts, non-harassment orders and exclusion orders, are not always achievable swiftly, and once in place don't always offer rapid enforcement responses. The Act aims to fill the gap with notices and orders that can be applied swiftly and enforced criminally when breached. The legislation reflects a policy choice to prioritise safety and prevention rather than waiting for harm to escalate to criminal charges or civil actions in court. Today I am going to cover what are domestic abuse protection notices and domestic abuse protection orders, what is considered abusive behaviour under the Act, who can ask for a domestic abuse protection notice and order, when and how a landlord can apply to the court to end a tenancy if there has been abusive behaviour, details of the criminal offences that have been created, the considerations of the welfare of children and the views of the child, and the effect of a DAPN or a DAPO on orders for contact and residence.